Hi, everybody. Hope you are having a great day. Um, hmm. Oh, that's interesting. All right. So, guys, we have, so you guys aware, the verdict in George Kelly came back as a hung jury, but we did not get the chance to go through it together, and I want to share that with everybody. So, we're going to start off with the 18th, and the jury had a question. We're going to go through some of these questions in their statements to the court, and then we'll end up with the verdict. We'll end up with some people talking about the results of it, and then we'll go from there. So let's start with the 18th. So this would have been Thursday last week.
All right, very well. We're back on the record in State versus
So there's a jury question. You might be wondering where the prosecutors are. They're on the phone, it sounds like, with the court.
Kelly. We received a note from the jurors at 4 p.m. The county attorney's on the line. Defense counsel and the defendant are here in the courtroom. The jury's obviously not present. The note that I have is from juror number 1, and is there an exhibit index for both the prosecution and the defense? So I'll hear what the parties have to say. My inclination is to give them an exhibit list and have the clerk prepare a redacted exhibit list just to show what's been admitted instead of showing everything that was marked and not admitted. And now Jose
I think
said,
that's perfect.
all right, now there's another note. They just told Jose they have another note. All right, well, let's do with the first one. Do you have any issue with that, defense counsel? We'll show you the redacted list if you want to see it.
Yeah, my only question was some of them were multiple photos. Were they just going to say photos, or how were they going to label?
Why don't we, and if Ms. Hunley or Mr. Jetty, if you want to come over, she's preparing a list that just shows what's been admitted. So we don't send the exhibit list back there with,
Sure.
And that's pretty reasonable. The jury's asking like for a list of all the exhibits. So they were all admitted. Having them as a list isn't problematic. If this was a case where they were, I would just say like you'd label them exhibit 1, 2, 3, 4, 5, 6, 7, 8, 9, not necessarily state's exhibit, because let's say sometimes the defense doesn't introduce an exhibit. They just use everything the state has used for evidence. But in this case, they had a ton of evidence on both sides. Yeah, totally reasonable. I've never heard of a jury asking for it, but it makes sense. It makes sense.
So, all right, why don't you, all right, so can we get a transcript? Here's the other note, which just came in. I'm marking these for 1824 at 4:07 p.m. Can we get the transcript of Dr. Tim's testimony? And that's from juror number 1 also.
That's a medical examiner.
No, there's no transcript.
No.
They need to ask a question. You can't. The poor court reporter.
All right, let's see. Now there's a.
Go to work right now. They gotta recall the testimony.
That was long testimony.
Yeah, but they just need to be told to recall the testimony, and there's no dispute, so.
Well, I know the court, I'm just looking for the rule. There's no transcript, but the court can have certain testimony read back to them if they can be more specific about it.
Yeah, if they have a specific question, I think the court can read back specific testimony.
Let me see if I can find the rule.
Oh, look, yeah.
All right, so why don't we answer the first question first? Why don't I, this is about the exhibit index. Why don't I just say, yes, one is being prepared for you and will be given to you as soon as it's available. Fair enough?
Yes.
That works.
Yes.
Yes, one will be prepared for your use and will be provided to you as soon as it is ready. Good. All right, I'll just write Judge Fink. 4:10 p.m. All right, so take this to them and then bring it back when they're done with it so we can make it part of the record. All right, now. What's that?
Not that I'm aware of yet.
Okay.
Guys, remember the prosecutors are on the phone right now talking to the state and the court.
That first. Thank you. All right, the clerk has prepared a redacted exhibit list that just show the exhibits that were in the court.
As we
All right.
speak.
All right, why don't you run, thanks. All right, and then we'll wait for you to come over here. Why don't you run another copy? And then you can give this to defense counsel, and then the other copy we'll give to the state when they get here. And here's, let me give this first question. Mark that number 1, okay? And I'll mark this number 2. Repeating testimony. Ms. Huntley, are you still on the line?
Yes, Judge, we are. We're listening. We just have you on mute.
Okay, no, I just
You
want to
don't
be,
hear
I just
us.
want to be sure you were still on the line. All right, repeating testimony, 22.3. If after the jury retires, jury requests that any testimony be repeated, the court may recall the jury to the courtroom and order the testimony read or replayed. The court may order other testimony repeated so as not to give undue emphasis to particular testimony. Well, let me tell you my preliminary thoughts and then I'll hear from the parties as well. Dr. Kim's testimony was lengthy. I think my proposal would be to respond to them would be there is no transcript, but if you're able to identify specific parts of that testimony, the court would consider having that read back to you. But I'm not inclined to just bring them in and have them read 2 hours or whatever it was at time. I don't know how long it was, but 2 hours more of testimony.
The state agrees to that, Your Honor. I think the court could, if the jury can identify what specific topics they need, that seems appropriate.
What are your thoughts, defense counsel? You can take a look at the rule. It's 23.3, subsection A.
Yeah, I think if we get something narrowed down by topic, then we could consider whether that would be feasible.
All right, let me see if I can come up with some language here.
Is this just states?
No, there aren't any defense exhibits on that.
There's no defense exhibits on it?
It's all state.
All numbers. No letters. Thought you were being biased. Just kidding. Thank you. Ours is shorter than theirs.
Oh, there you are. Okay. I'm just trying to craft a response with that.
All right, guys. They're trying. Basically, the issue is we want the medical examiner's testimony, the pathologist's testimony back, and they want a transcript of to read. And ultimately, you don't get to do that. That's not how this works. That's not how any of this works. And we're going to skip ahead to where he actually talks because right now they're just reading, and there's nothing. Literally, like this is probably the only time you use a law book, so you don't have access to a computer.
Here's what I drafted in response to note number 2 about the transcript of Dr. Tim's testimony. I wrote as follows. Dr. Tim's testimony has not been reduced to a transcript, so no transcript is available. The court, however, may authorize the testimony read to you in open court. Dr. Tim's testimony, however, was lengthy. If there is a specific part of that testimony that the jury considers to be particularly important, the court would consider a rereading of that portion of the testimony if that is important to your deliberations.
No objection, Judge.
Any objection?
No.
All right, then I'll put Judge Fink. And that's at 4:18 p.m. Okay, Jose, so then take this into them again, let them read it. Hopefully I try to print as clearly as possible and then bring it back for filing.
State's reviewed the exhibit list you provided for the state and the defense, and we don't have any objection to those going to the jury.
Does that have the
And that's the thing, guys. Those scraps of paper, they get the instruction and it has to be saved. You don't make a photocopy. You keep the original. So that slip of paper is what the jury wrote on. They try to write the answer back on that so there's no confusion. They get lost.
defense exhibits on it?
Two
Yes.
lists. There's
One time I had a trial and the jurors accidentally found a pad of Post-it notes and they wrote a question out on a Post-it note. And there was nowhere for the judge to write back except on the back side. So that he wrote down, please rewrite your question on a slip of paper. That was kind of funny
two separate lists.
because they had sat there and they had made it like, that guy had sat there and was like, made it all fit nice and clean.
Can you grab that? Let me see what you have there just so I can look at it too, those two lists.
So they're looking at the exhibit list. No big deal right now.
The first note was requesting an exhibit list of exhibits that had been admitted in evidence, one both for the defense and for the state. The clerk of the court has prepared such exhibit lists. The exhibit list that the clerk keeps includes all of the exhibits that are marked and whether they've been identified or admitted or not.
We'll get
So
to
the
those,
clerk's
Mitch.
prepared a redacted list, which just includes all of the exhibits by number, date identified, date admitted, and a description for both the defense and the state. And the parties have reviewed those. So when the bailiff comes back, I'm going to have him take these lists and give them to the jurors. I have a duplicate copy and I want to make this part of the record so we have a record of what we gave to the jurors. How should we mark this? All right, so these are, I'm going to write something on top of these. I'm going to write response to jury note number 1. All right, so I marked both of these response to jury note number 1. I'll give these to the clerk. So that'll be filing in for a record. All right, now you can take. Oh, okay. So they didn't write anything? Okay. All right, so there's no response on that, so I'll give that note to the clerk. You can take these into the jury. This is the response to the request for the exhibit list. Yeah. Okay, so the jury has asked to be excused for the day. So we'll do that. The second note from the jurors had to do with their request for the rereading of Dr. Tim's testimony. I wrote a response that says, basically, after having consulted with counsel, that there is no transcript of Dr. Tim's testimony. There's no transcript of any of the witnesses' testimony as far as I know, certainly not a final transcript. So I responded that there is no transcript of Dr. Tim's testimony. One has not been prepared, so one cannot be provided. However, if there's a particular part of Dr. Tim's testimony that is of particular interest and importance to the jury, the court would consider having them come back into court.
Generally, the answer is no. You're not hearing, you're stuck with what's been talked about.
Have a rereading of that portion of Dr. Tim's testimony. Dr. Tim's testimony was very lengthy. I know it was probably like 2 hours or so. So it's not feasible to read back the whole thing. But if there's some particular part of her testimony that they think is important and they can identify that, then we'll consider having them come in tomorrow and read that.
Yeah.
I suppose it would have been helpful to know that now. So
That's what I was
Denise
going
could
to
have-
say. If I could make a suggestion, I would ask that we give them that response before they go home tonight.
I did,
that way
I
maybe
did,
they
and they
can-
just sent it back.
Oh,
So
Oh.
they're on their way out. But yeah, so anyway, we'll find out tomorrow. Maybe we'll see what they say tomorrow. But
just thinking about Denise. She could put it together.
she'll start working on it. I knew she would. All right. So
And that's the thing. The court reporter is going to start belting out the transcript on that in case they have to do it. That's a lot of fucking work.
we've excused the jury for the evening. I think Jose said they're going to come back at 8:30 tomorrow morning. All right. So I think you're all excused for the evening.
So that ended Thursday. Then we moved into Friday, and this is Friday morning. Mhm. Did this? Are you
I guess
fucking
that's all
kidding
set.
me? It didn't switch
All
over.
right. Tiv
God damn it!
or an exhibit entered. Second
Didn't switch
thing
over,
is not a
guys.
question, it's a request. Can we get multiple copies of the jury instructions, one for each juror?
Guys, I didn't have a stroke. I'm listening
Let's
to it.
deal
It
with
didn't
that one
switch over.
first. What's the
For
state's
fuck's
position
sake, chill
I
your
don't have any
titties.
objection to that, Judge.
to the instructions?
Sure.
We don't have an objection.
All right,
either.
good. So let's make sure,
So they wanted a set of jury
Wes, can we
instructions,
get-
everybody.
multiple copies of the jury instructions, one for each juror.
Yeah, and that's perfectly fine. They're allowed to have jury instructions. The fact they all didn't get a copy is kind of stupid to start with.
All right, let's deal with that one first. What's the state's position
I don't have any objection to that, Judge.
to the instructions?
Sure.
We don't have an objection.
All right,
either.
good. So let's make sure, well, hold on. We'll copy off, 7 or 8 others. Just make sure they're all working off the same final instruction. All right, what about the site visit?
It's substantive, Your Honor.
Substantive?
Yeah, I mean, they're allowed to consider what they viewed out there as substantive evidence.
What was their question?
The question was, we need clarification of the site visit. Was it demonstrative or an exhibit entered? Admitted.
Yeah, I don't know what.
I don't know why it makes a difference.
I think they're
Yeah.
trying to determine if what they saw out there was substantive evidence or if it's just a demonstrative, and I think it was substantive.
I don't know do you have a position? It's the equivalent, well, the parties stipulate.
It doesn't really matter if it's substantive or if it's a demonstrative aid. The demonstrative aid helps you understand what everybody's talking about because that's not the crime scene as of the date everything happened. That is not in the same or substantially similar condition. So it doesn't really matter. And I appreciate them being technical and wanting to do this right, but this is not correct.
That locations 1 through 15, was it, were the locations that were specified, on the map, on the key to the map or the key to the list that they got, right? I mean, so
Right.
I think an answer would be to that
It's
effect.
evidence
The locations that were marked 1 through 15 were agreed to by the parties as being the locations identified in the key to the map, and you can consider that as substantive evidence of those locations.
Well, don't forget, Judge, don't forget that they added another point, and that was that tree. So I
Oh, the
don't know
tree
if you
as
want to
well.
be that specific and just call it, the whole thing is whatever you want to call it. But I think they can consider that location, in our opinion. I don't know.
Yeah, I forgot about the tree, but 15 was the last thing that was was it the
Pump house.
the other
Pump
pump
house.
house that
Yeah.
we drove them out to?
Justin, I got there's a whole description down below. Basically, he's accused of shooting an illegal alien that's running back and forth across the border, and he's accused of murdering the guy.
And well, 16 was not
Designated.
marked, but it was the end of the border
Yeah.
wall. And the
Oh, yeah.
tree, the parties went out there and agreed on the tree. So, right.
Yeah, I think anything they saw there was substantive evidence. That was the purpose of the
Yeah.
visit, was for them to judge distances and what they could see, all that.
I mean, I agree. I just wanted to hear what your position.
Yeah, I don't think we need to, personally, I don't think we need to say 1 through 16, whatever, just the site. I mean, it's just, they may consider that.
Okay.
Just
Judge,
leave it vague.
That does raise an issue, though. We had asked that the photos that were taken by court administration be made a part of the record, just for the appellate record, in case anyone ever raises an issue about what happened.
All right. Well, that's a separate issue. Let me deal with this.
Sure.
All right. All right.
Let's skip ahead here.
Well, you already have all those copies. Any objection?
No objection.
All right. You can give this to them, and when you bring it back after they've seen it, give it to the clerk, and it'll be made for filing, and it's 8:45.
Hold on, we're gonna.
Consider the site visit. All right, so answer one, you may treat / consider the site visit as an exhibit. It is not demonstrative evidence. Number two, yes, extra copies of the jury instructions will be provided. Any objection?
No objection.
All right, you can give this to them, and when you bring it back after they've seen it, give it to the clerk, and it'll be made for filing, and it's 8:45.
And then can we talk about that issue with respect to putting the photographs in for the appellate record?
Yeah, we will. No, I guess something else I have to do.
Okay.
All right. We're recessed.
Please rise.
So that part is done, but there's still a little bit left because obviously 18 minutes. So we're gonna go to the next spot here. A little bit later in
Back
the
on
morning.
record show the presence of defense counsel and the defendant. The jury is not present. We have another request from the jurors. Who do we have on the line from the state?
Your Honor, Kim Hunley and Mike Jetty from the state.
All right, good morning. So I marked this question came in at 10:05 a.m. Actually, it's not a question. It's a request. We need clarification on evidence admitted for a limited purpose and other acts, parentheses, pages 19 to 20, of final instructions. We are missing context.
Your Honor, I would suggest that what the state offered
There's not really a whole lot you can do about that. The instructions are the instructions. You have to work with them, is what I would argue.
in terms of the limited evidence be read to the jury or be provided to them on the limited evidence issue. And we can talk about, and I wouldn't have an objection to sending them a message with respect to the text messages on the other act evidence.
Judge, I think that unduly overemphasizes that kind of evidence. We would suggest instead maybe something where you just told them at various points during the trial, I provided certain limiting instructions regarding certain pieces of evidence, and your notes and recollections can refresh that. But for example, I talked a lot about hearsay and things were offered for limited purposes. So what you recall about the trial is what that is about.
Right. I mean, but the problem with that is that's what I actually did in the closing instructions, and obviously it's not enough. What I would, and the reason I did that,
Even though it's
and
not enough, that's
the reason it continues to be a difficult
problem.
challenge to comply with this is that, there are a number of different things that were admitted for limited purposes, for different reasons, different types of evidence for different reasons. But I think we should
Monday.
try to respond to the request for information. So what I would suggest is that I write them back a note saying we intend to respond. The information is somewhat detailed and involved. We're working on a response. It'll take some time because it needs some work, and we'll get it to you as soon as we can complete it. Now, I would have the parties see what you can agree to as far as what the evidence was that was subject to the limiting instructions and what the limiting instruction was at the time.
May I get clarity? Is the note asking for which ones, or can we ask which ones are there in question about whether it has a limiting instruction?
I thought, yeah, it does not. It's just as read. Okay, we need
I mean-
clarification on evidence for a limited purpose and other acts. See pages 19, 20 of final instructions. We are missing context. That's all.
I mean, can we ask if there's a specific question or evidence or a statement made that they're in question on whether it is or not, versus giving them the whole trial of it?
I'd object to that, Your Honor. They've asked generally, and I think we should answer their question.
Well, I think we can do both. I think we can do both. So what I intend to write is just what I said. We intend to respond to your request. We are working on it. It will take some time because of the number of different things that were admitted in trial or for which a limiting instruction was given. However, if you have some specific evidence and you're concerned about what the limiting instruction was or whether it applies to that evidence, please let us know and we will address that specifically. So let's try and do both.
But
And we can get a response back. If they say it
I like
was
that.
concerning this particular item of XXX or whatever, then that
Brings
helps us.
clarity.
Or they
But in
could
the
just be
meantime,
reading the
I'd like the
instructions.
parties,
They could also just be reading through the instructions to have a general question, which then this is all for naught. So they should clarify first.
to work on this, and that would expedite the process and expedite any decisions that the court has to make about how to respond.
Well, Judge, I've already emailed to the parties and to the court what my proposal was with respect to the limiting instructions on Detective Barba and Detective Rodriguez with respect to Miguel, Ramon, and Daniel. And so I've already sent that language. If council wants to take a look at it and see if they want to make some edits to it, we'd certainly be happy to talk to them about that and see if we can come to a stipulation to come back to the court.
That's what I'm asking everybody
Well,
to do.
My concern is if we're going to give them some, it has to be all. And I'm not sure that's what they're asking for again. But, I think that's a lot of work because the court reporter, I guess, would be the only source of every single instruction. And so I'm just saying is I don't want to do just what the state wants that on. I want all of it because we don't know what they're asking.
All right. Let me craft an answer here. Thanks.
So, let's skip ahead to the answer.
We can respond. All right, here's what I wrote. The court understands the request and is preparing a response. Two different forms of response, however, are available. First, we can prepare a response that tries to list all individual items of evidence admitted for a limited purpose. We can do this. It will, however, take some time. Second, if there is a particular item or items of evidence that was admitted for a limited purpose and the jury has a question about those particular items, the court will prepare a response as to why that item or items were admitted for a limited purpose. Either response is acceptable and doable. Please let us know how you would like us to proceed. How's that? Ms. Hunley?
Your Honor,
In the meantime, I still want the parties to start working on the more comprehensive response and let me know what you come up with. So if they decide they want the comprehensive response, then we can try to make that happen.
and Your Honor, we're going to head over as soon as we get off the phone and start working on that with counsel. But I would still like to provide a comprehensive response to the jury as to those two issues, one way or the other. We requested it before. I don't want to waive any objections or any issues with respect to that. And so I think they're entitled to know those two things. But aside from that, no objection to your response.
All right, very well. So I'll give us the bailiff to take back in there and come on over, get working on that with defense counsel. I assume we'll get an answer back from the jury pretty quickly. And once I get that answer, I'll come back in court and let you know what they say.
Sounds good. Thank you, Judge.
All right, we'll stand in recess. Thanks.
So we're going to speed this back up.
Bailiff, they're holding on to the note. They're going to decide how to respond. So that's what they're doing. So in the meantime, keep doing what you need to do. But I just want to tell you that's what their response was. So they haven't returned the note. They're working on it, and they're going to decide how to respond. All right?
Examiner. They're still thinking about it.
Do they need the skeleton?
I would like to make a record on it again at some point, so just so the court knows.
Thank you. We're in recess.
All right, guys. So that was it for the 19th in the morning. We have the 19th in the afternoon. And if you guys are not paying, you guys don't realize this is Friday afternoon when they start talking.
All right, we're back on the record in State versus Kelly. The records show the presence of all counsel and the defendant. About 10 minutes ago, we got another note from the jurors. For the
Yeah, Wombat, they get to go in and out of court, but the prosecutor's office is located in the courthouse. So they can come back and forth all the time. You know, the defense has an office somewhere else. So yeah, they kind of have to stick around. That's a disadvantage, but oh well.
record, I previously instructed my judicial assistant, Jose, who's also the bailiff, that if the jury ever submitted a note that had any kind of tally or numerical representation about what their votes were, he was to close the note and not show me the note. And the reason I did that is I've had this happen in a number of trials before. The jury instructions, the final jury instructions that I gave clearly state to the jurors, and I think I emphasized to them again, if you have a vote and you have a note, you're not to inform the court about where you are in the vote numerically. Well, apparently they've done that. Now, I haven't seen it. I intentionally didn't look at it. I had them staple it and gave it to the clerk. If you would just write on there, Valeria, one that came in about 1:45 today on April 19th. But I haven't seen it. So I don't know what it says, and I don't think it's appropriate under the law for me to look at it. And that's all. Apparently, it's in the note. It just has my understanding, it has the counts of the charge and just some kind of tally of where they are. And then they told the bailiff orally, well, what do we do now? And I sent the bailiff back to give them instructions.
Guys, that actually that happens a lot more than you'd hope it would. Doesn't happen a lot, but the amount it happens is still quite a bit, where they mark down where they're at.
Questions for the court have to be put in writing. So that's where we are. But in the note doesn't ask the court to do anything at this particular point in time.
Your Honor, I still don't think we've answered their questions from earlier.
I did answer their questions, but they haven't sent the answer back. So a question on the limiting instruction, I read it, and it says we can do this either way or both ways. We can answer your question. We can provide you with that information, and tell us what you want us to do. And we haven't heard them back. So if they had answered back, then we would have gone forward. But right now, putting that aside, let me hear from the parties. I mean, I haven't been asked to do anything. And so unless and until I'm ever asked by them to do anything, my intention is not to respond.
Well, it's the state's position that we need to give a full response to their request on the limiting instructions. So the state is still requesting that, specifically with request to Detective Rodriguez.
All right, I know what your request is. I'm not going to do it. I already responded to that request. I responded to the request that they gave me. I told them what we can do. I said the court can respond. We can give you all this information. If you have some specific area of concern that you want, we'll answer that. If you want it all answered, if you want us to tell you about all the limiting instructions we gave, we'll give you that detail as well. Put it back in that court. Haven't heard back from them. From that, I assume it's not that important at this point in time. Anything else record you want to make about the note that was just sent out? Other than what you've already stated.
It sounds like you've already responded, Judge? Or,
No, there's nothing to respond to. They just sent a note out with a tally about where they were on the various counts. And I haven't responded in any way, except the bailiff told me they orally told him, well, what do we do now? And he did not respond appropriately, and he informed me of that. And I sent the bailiff back and said, if you have any questions of the court whatsoever, everything has to be done in writing. And that's where it sits. What's the defense position?
I think we can leave it there unless and until they send us something that is in writing. If they say we're stuck or something like that, then we can give an impasse instruction. But I think we need to wait for something from them.
That's what I think as well. But start looking at that. I think generically they're called Willits instructions. There's a Arizona revised.
It's not called Willits, Your Honor.
I mean, that's what we
Willits.
kind of colloquially have referred to them. But there is an Arizona revised jury instruction that is recommended for the court to give, if appropriate, under the circumstances, when the jury has indicated they're at an impasse.
I was just wondering, Judge, if you wanted to send a note to remind them to not tally up on future notes. And I don't know. Whether it's necessary or not, I'm not sure. I mean, we hate to come back with
it can't hurt. I mean,
because you don't want another one saying we're hung, we can't figure out what do we do. Here's our tally. Then it makes it where you can't read it.
Can't even read the note. Right.
Yeah.
That's true. All right. I think that's a good idea. Let me have something to write with you. Something.
You're right. And I know you believe that I've made my record, but I indicated earlier I needed to make a further record, and I would like to make that further record, which
You
is
can
that
do
the
that,
state-
but I'm trying to deal with an immediate
Sure.
issue right now. So let me deal with this. 2:05. And I put April 19th, 2:05 p.m. Jurors, you are reminded not, underscored not, to inform the court, bailiff, or anyone
agree.
else what your
All of them
numerical
try
vote counts
harder.
are on the charges. All right, I'll give this to, any objection from the state?
No objection, Judge. And just
All
for
right,
the
let me give
record,
this, we'll have the bailiff take that.
and just for the record, Your Honor, I think you meant an Allen instruction. Willits is if there's lost or destroyed evidence.
Oh, that's right. You're
Is that
right.
what you
Yeah.
meant?
Yeah. I'm sorry, I forgot that. Thank you for correcting me.
Also, whoever was trying to say, like, oh, Allen got repealed, they don't do jury Allen instructions. They call it an Allen instruction.
Do you have that? Does everybody have that proposed, Raji? We're not there yet. I just take a look at it.
Standard 53, is that what we're talking about? The impasse instruction?
You're right. I think so.
I
Are-
have it in front of me.
Okay, take a look at that. We're not there yet, but the way things look, we may be soon. They, for the record, the jury began deliberations at 8:30 this morning. Well, let's go back. Yesterday, they began deliberations at 2:40. It took us a little while to get some of the exhibits back in there. They recessed at 4:30, so that was an hour and 15 minutes. They began deliberations at 8:30 this morning. We got the note at about 1:45, 1:50. They did have lunch brought in. I don't know if they worked through lunch or not, but they began at 8:30 this morning and sent the note out at about 1:45, 1:50, and stayed in for lunch. Ms. Hundley, you can make an offer of proof and a record. Why don't you just print something up? I've got other things I need to do. If you would write something or print something up, and then you can file it and make it part of the record.
Well, Your Honor, it's just the document I already prepared and already submitted to the court that I just believe the state is prejudiced without the jury receiving that information.
Mhm.
And I don't believe they know how to ask for it because they don't know what it is that they need the information on. So I think pitching it back to them.
The poor state, heaven no, it's so bad, it's so hard, oh no. Fuck off. Don't care.
Is not appropriate. I think that we should offer them the information that they asked for.
Okay,
That's all.
understood. Any change in the position from the defense on that?
No.
All right, stand by. We'll be in recess.
Please rise.
All right. So we're going to go a little bit more, and they come back very shortly.
10 p.m. Not unexpectedly, the record will show the presence of counsel, the defendant and defense counsel. Not unexpectedly, we just got another note. I marked it 2:10 p.m. The note reads as follows. We, as a jury, are at an impasse as to a unanimous verdict. We're looking for guidance as to how best to proceed. I'll give a note to the clerk.
Which is funny. They said they're stuck, and very shortly after, they came. I mean, this is at 2:10, and then this, they were 5 minutes later, it comes back. And they're just like, we're still stuck, man. We're still stuck. What do we do? You know, what do you do?
As to a unanimous verdict. We're looking for guidance as to how best to proceed. I'll give a note to the clerk. What's the defense position?
I don't know that we need to give the impasse instruction just yet. I think maybe just another note
I
saying.
can't hear it. I don't think.
Oh, I don't think we need to give the impasse instruction just yet. Maybe another note saying, do your best, see if you can make any progress.
And and when I heard that, these two are playing for a fucking acquittal. And I think they thought this jury was on the verge of acquitting. Turns out they were right. These guys are going all out about don't start using the alley instructions, because once you start reading those, there becomes an issue of mistrial becomes very likely very quickly if they still can't make it work. So there's a reason why the defense just kept pushing.
I think when the jury indicates they're at an impasse, we have to give the impasse instruction.
There's that.
So the impasse
That's not true. You don't have to.
instruction, just make sure we all have the same thing. We're looking at the same thing as standard criminal 53, and it reads as follows. This is offered to help you, not to force you to reach a verdict. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a just verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your views and change your opinion if you become convinced that it is wrong. However, you should not change your belief concerning the weight or effect of the evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. You may wish to identify areas of agreement and disagreement and then discuss the law and the evidence as they relate to the areas of disagreement. If you still disagree, you may wish to tell the attorneys and me which issues, questions, law, or facts you would like us to assist you with. If you decide to follow these steps, please write down the issues where further assistance might help you bring about a verdict and give the note to the bailiff. The attorneys and I will then discuss your note and try to help you. I do not wish or intend to force a verdict. We are merely trying to be responsive to your apparent need for help. If it is possible that you could reach a verdict as a result of this procedure, you should consider doing so. Please take a few minutes and discuss this instruction among yourselves. Then advise me in writing of whether we can attempt to assist you in the manner indicated above, or whether you do not believe that such assistance and additional deliberation would assist you in reaching a verdict. If we're going to give them an instruction, I think we had to give them this one because it's crafted to be neutral, offering help, clearly states we're not intending to try to force a verdict, coerce a verdict, or influence a verdict. It's just tell us whether you need help. Can we help you? Is additional time needed, or are you clearly at an impasse?
In my experience with my background, I have found that sending them back to do their due diligence, some note to say, keep trying before they just throw the towel in easily, and then follow up with this has helped a lot where we did get verdicts. It's just my experience.
The state opposes that, Your Honor. We'd ask for the impasse instruction. It's specifically designed for this situation and, as the court indicated, is neutral.
Let me get a formal statement from the defense. You, co-counsel, you can talk together, talk to your client if you need to. It's an important decision. If you want to involve him, do so. I can step off even, but really the question is whether or not I give this impasse instruction. If I give further instruction, I think it's appropriate to give the impasse instruction because it's crafted to comply with the case law and to be neutral and to be non-coercive.
The instruction is not a concern. We know that's crafted for that purpose, and so that's not our objection. We would just like them to continue trying for a while before they get back and give us more information that they absolutely can't. The same issues may be the same issues in another trial down the road. So I think what I have found by just asking them to get back to work and continue to try, and then maybe they'll diligently try a little harder and then follow up with this impasse note if we get another one down the road.
All right, I understand your position, but if I am going to give a reply, a response, then I'm going to give this instruction. But I won't give it. Well, I'll consider not giving it if the defense objects. I mean,
We'll take a minute.
okay, I'm going to come back in a couple minutes. We'll be in recess for 5-10 minutes.
We rise, people, order.
All right, chat. So he gave it, and it's like, all right, well, fine. Give him the instruction. And we come back. And it's 2:13. Look, like this is the sign. This is the funny part for the judge. This should be a sign something's not working. You keep doing this. You tell them keep going back, and they're like, no, we're done. So here comes the defense.
Records for the presence of counsel and the defendant.
And real quick, we're going to read some super chats real quick. But Unknown Hero for $2 says, well, I'm going to come. Well, don't come. Not yet. Arson investigator for 1999. Thank you. Is saying the judge has to be upset Kelly is a free man. Well, he's still under indictment. He's not free yet. Mitch says, is he heading to new trial? We'll find out on Monday. Ashley says, Sean, it's fucked up. Fix it, please. Debbie says, say something so we didn't have a stroke. Well, okay. Eric Rodriguez says, I was watching a trial in my country where a dude was representing himself in an aggravated sexual assault case. He ended up with a hung jury, surprisingly. Well, good. That's good to hear. That's really rough stuff. Justin is saying, did any ballistics evidence point to the defendant in any way? Nope. Guy had a bullet hole in him, and that's it. Guy had a bullet hole in him, and George Kelly had a gun. That's all we know. Stray says for $2, MLS God of Law is only 82 subs away from 1,000. Guys, remember that's David from Making Law Simple. After the Hales acting like assholes, Cuppy struck his channel into non-existence. He switched over to his other channel. Unhung Hero says, based on mistrial, could the judge do a DV? We'll get to that. I think he could have, but I don't know Arizona law. And C. Suiter for $9.99, thank you, is saying, thank you for not leaving us hanging on this. So, of course, this was a good one. This was a phenomenal case. And Lefty's a new member. Thank you, Lefty. So we're going to get back to this. But, guys, look, this is a hint. This is a hint that the jury's like, we don't want to keep doing this. We don't want to keep doing this. I think the judge realizes the state had a shitty case. I think so, too. So, I think so too. But this is a hint, Judge.
I've been thinking some more, and I am going to I'm going to do what defense counsel suggested. This jury, as I said, went out at 2:40 yesterday. It took us a while to get the evidence in there, and they did deliberate a little bit yesterday, and they deliberated today from 8:30 to a little bit before 2 with a lunch break. Not sure whether they worked before lunch. It's a 4-week trial, a lot of complex information, a lot of proof, a lot of evidence presented, and there's a lot of issues. I mean, there's no question.
No, it's not very complex. It's not very complex. There's not a lot of proof. I mean, let's not bullshit ourselves here, honey.
There's a lot of facts to be looked at in this case. I just don't think they've worked long enough or hard enough at it. So I'm going to bring them in, and I'm going to tell them, number one, I don't know what their vote count is. And again, they're not to tell me, but it's a 4-week trial. A lot of work and effort's been put into it. I'm not trying to coerce a verdict or influence them in any way, but I think they just need to keep working. Another possibility would be, we are here on a Friday afternoon. I'm always concerned when a case goes to a jury on a Friday afternoon that influences their process. Another option I can offer them is, look, if you want to break today and come back Monday and start again Monday, that's another thing we can offer you. Sometimes that's an effective thing to do, which is just to take a break and come back and start afresh on another day.
He was not letting them leave.
For the record, this state opposes that, Your Honor. We're asking for the impasse instruction. I believe it's specifically designed for the situation. The jury specifically said they're at an impasse, and that covers all of the issues.
Yeah. All right.
We're in agreement with your suggestion, Your Honor.
Okay. Then let's bring in the jurors.
So we're going to get to the judge yelling at the jurors, basically. It gets good from here. Yes, look at that. Did she look confident? She is not confident right now. Oh, peas puddling in her pants right now.
It's 2:35 today on a Friday. This case went to you for your deliberations, ladies and gentlemen, about 2:40 yesterday afternoon on Thursday. We took a while to get the evidence together, put it all together so you could have it all available to you in the jury room. Then my understanding is you began your deliberations again this morning at 8:30. You had lunch. I don't know, did you work through lunch or did you just take a lunch break? Work through lunch? All right, that's good to know as well. And then your latest note came in at 1:50 p.m. about the situation. Again, just to remind you, I know I've written it back in the note, do not advise me numerically of where you are voting, okay? I had it stapled up and filed with the clerk, so I don't know where you are. Please don't do that again. That has an effect that I wish to avoid. Now, I have to tell you, it's my opinion that you haven't worked at this long enough. This was a 4-week trial. A lot of evidence was presented, a lot of information, some of it very complex from a variety of different witnesses.
What's that complex? Come on
I don't know
now.
how many witnesses we had testify, but quite a few, and they all gave important information. So very complex information. I understand the issues are complex, but to come back on a Friday at about 1:50, I don't think you've worked at this long enough. I am not trying to force or coerce a verdict, all right? That is not my intention. That's not my job, and that is not what I'm doing. But I do have a
Kinda is, though.
responsibility after a tremendous amount of work has been put in to getting this trial to this
Kinda is, though.
place where we are, by the lawyers, by the court, all the resources that have gone into it, and all the evidence that's been presented to make sure that you do your job, follow your oaths, and to work as hard and long as you possibly can to reach a verdict. Again, I'm not trying to force or coerce a verdict. And if there's things that you need and we can help you with, other information or evidence, that's what we're here to do. But in my opinion, which is the one that matters at this point, you have not worked at this long enough. So I'm going to send you back in a moment to continue the deliberations. Now, also, it's a Friday afternoon. And from my experience, from a lot of trials I've done, sometimes, and this is something else for you to consider, sometimes it's good to take a break. I know everyone's prepared and eager to resolve this matter in this case, but another option would you can be recessed for the day and come back Monday. Sometimes it's good to take a break, step away from it and come back as a group, again, 8 persons on Monday after a weekend and start the deliberations again. So that's another option for you. So what we're going to do is I'm going to send you back in the jury room. I want you to keep deliberating, discuss it, keep an open mind, reevaluate your positions if you feel that's appropriate, and continue to work on this case. All right? And if you decide you want a break for today and come back on Monday, as I've suggested, pass a note to the bailiff, and then we'll just excuse you for the day and tell you to come back Monday at 8:30. But I want you to keep working. All right? You're excused to continue deliberations. Thank you.
Please rise if you prefer.
So right now it's 2:30, guys. And we're back again.
All right, we got another note from
3
the jurors.
We're back at 3 o'clock. 30 minutes go by. Here we go.
I had it shown to counsel just because this juror writes so small. I just want to make sure you have the same reading of it that I do. The way I read this, were the SO reports entered into evidence? If so, can they be shared with the jury? Is that the way you folks read it? All right. Let me hear from the state first.
Your Honor, I think we have to answer, they have all the evidence that's been admitted.
That's fair enough, Your Honor.
And police reports, and I think we covered this when it happened on Friday, guys. Police reports are not admissible. Not in this context. They are not exhibits. They are used as aids to refresh recollection, but they are not exhibits themselves. I said, what you've got is what you've got. That's a fair answer.
I think we can tell them that they can have additional testimony if they request it as well. There's an additional instruction that indicates that and a rule that allows it as well,
And
if that would help them.
Our position would be to not suggest that.
I agree. I agree with the defense on this. It needs to.
Have any reports?
Let's see how he
We
phrases
didn't, we
it.
didn't have any reports that were admitted, right? From the sheriff's department.
That's correct.
Not police reports, Your Honor.
Right.
Obviously, that's because we can't admit them because they're hearsay.
Is by rule, the admission of evidence stops at the close of the trial. No other evidence can be admitted. The SO reports were not admitted during trial, hence they are not in evidence and therefore cannot be shared with the jury.
Mhm.
Any objection?
Yes, the state objects, Your Honor. It sounds like we could admit them, which we cannot. They're hearsay. And I think that improperly emphasizes that they weren't admitted and seems to point the blame at the state for not admitting evidence, which we're not allowed to admit.
That's a shame. What are you saying
I
is
don't have
a
a
wild
position,
rule?
Judge. I think how
Which
you
part?
crafted it is fine, but I understand the state's objection.
This is the instruction or the answer I'm going to give to the jury. And it's 3:15. We're in recess.
All right, so 3:15, guys. And at 4:00, we're back again. So about an hour has gone by.
And the defendant, it's 4 p.m. I marked this latest note from the jurors, 4 p.m. The note says, jurors would like to be dismissed and to return Monday at 8:30 a.m. Any objection?
No.
No, Your Honor.
All right, so I'm going to write, you are dismissed.
Well, I agree with the state's point that they were hearsay and they couldn't have been brought in. But I think, yes, there's nothing wrong with clarifying these aren't allowed to be admitted. It's not as though evidence is being hidden from you. I think that's a fair point to the jury, but you can just say all the evidence you have to you is all the lawfully exhibited evidence. That they can get additional testimony? Oh, yeah, that's that is a weird rule, but I don't think it's necessarily a problem there. So they're also leaving for the day. So we'll move into Monday very quickly here, guys. Hold on.
Response I wrote is as follows. You are dismissed. Please return to the jury deliberation room Monday at 8:30 a.m. to continue your deliberations. Remember and comply with the admonition of the court.
That works for us, Your Honor.
Yes, Your Honor.
All right, I'll sign it, Judge Fink. Hand it to the bailiff to be delivered to the clerk. And we're adjourned until 8:30 a.m. Monday morning. Have a good weekend.
Your Honor, could I address one issue first? We've requested a copy of the JAVS recordings of the trial in this case, and pursuant to Administrative Order Number 2000.
And guys, the JAVS recording is this right here. This thing is the JAVS. This whole thing, the recording of everything, the court recording internally is the JAVS system. So JAVS. And if you guys aren't, it's like an actual thing. And this is JAVS. It's Justice AV Solutions. And they're the worldwide leader in court and hybrid courtroom and recording technology. So you see, they got all kinds of neat stuff here. So they do quite a bit. So that's what they're referring to with the JAVS recordings.
7-015, it indicates that if a party requests a copy of the JAVS recordings, they're entitled to them. And I was told by the clerk of court that the court was indicating I'm not entitled to them. So I'm just trying to sort that out.
I understand. It's been brought to my attention. Put your request in writing, file it with the clerk in connection with this case, and the court will give you a ruling.
Okay.
We're adjourned until 8:30.
Please rise and be prepared.
So that happened there. And basically what was going on there, they wanted it, and the clerk's like, well, I can't give them to you. And the judge is like, we'll fix that. So here is Monday, guys. This is where it gets important. Here we go.
All right. The records show the presence of Ms. Hunley for the
This is the shit that matters, guys. We're getting to the issues about verdict.
state, counsel for the defendant, and the defendant. The jury is absent. The jury began deliberations this morning again at 8:30 in the morning. They took a break for lunch at 2:50 p.m. The jury forwarded the following note to the bailiff, who forwarded it to me, and copies have been provided to all counsel. Judge Fink, the jury is still at an impasse, and we don't feel further deliberations will
I think that's net, Your Honor.
net. We do not feel that further deliberations will net a unanimous decision. Are there additional instructions we can follow? Signed juror number 1, who's the foreperson. I mark the time, and I'll give the note to the clerk with today's date, 4/22/24. All right. Let me hear from the state, and then I'll hear from the defense. Ms. Hunley.
Your Honor, the state requests that we provide the impasse instruction provided in the Raji's.
The standard from criminal 53.
Yes, Your Honor.
Thank you.
We're in agreement with that, Your Honor. We think it's time for that instruction.
All right, and before we get there, I waited a few minutes before I came in to make sure you had time to discuss the situation with your client. But if you need more time, I'm happy to give it to you. I want to make sure you've had a time to consult with Mr. Kelly.
I think we're okay, Your Honor.
All right, so
Judge's like, fuck it. Let her rip. Send it.
everyone is in agreement the court should get standard criminal 53 impasse instruction. Right?
Yes, Your Honor.
Yes.
All right, very well. Then let's bring in the jurors.
So he's going to read the impasse instruction to them all together.
Counsel and the defense.
It's funny he's not standing up. Normally the judge does stand up. And look at him. He's just like, fuck you people. You can't fucking get this verdict right.
Thank you. Please be seated. The record will show the presence of all 8 jurors, counsel, and the defendant. Good afternoon, ladies and gentlemen. I received a note from juror number 1, who is the spokesperson, I assume the foreperson for the jury, that the jury is at an impasse. And the request was, are there any other instructions that we can follow? I do have an instruction. It's a formal instruction. I'm going to read it to you now, so please pay close attention. This is offered to help you, not to force you reach a verdict. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a just verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and change your opinion if you become convinced that it is wrong. However, you should not change your belief concerning the weight or effect of the evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. You may wish to identify areas of agreement and disagreement and then discuss the law and the evidence as they relate to the areas of disagreement. If you still disagree, you may wish to tell the attorneys and me which issues, questions, law, or facts you would like us to assist you with. If you decide to follow these steps, please write down the issues where further assistance might help bring about a verdict and give the note to the bailiff. The attorneys and I will then discuss your note and will try to help you. I do not wish or intend to force a verdict. We are merely trying to be responsive to your apparent need for help. If it is possible that you could reach a verdict as a result of this procedure, you should consider doing so. Please take a few minutes and discuss this instruction among yourselves. Then advise me in writing of whether we can attempt to assist you in the manner indicated above, or whether you do not believe that such assistance and additional deliberation would assist you in reaching a verdict. That's my additional instruction to you. If any of you wish me to read it again, it's very important. If you need to hear it again, I'm happy to do it. All right, seeing none. Did you understand the instruction? Very well. I'm excusing you once more to deliberate further and consider this additional instruction that I've given you. We'll stand in recess until we hear from the jurors.
Please rise and be prepared.
The fact he keeps walking off is not something I'm impressed with. Like, he should wait till the jurors are done and then walk out. So I get paused, and now they're back. Like, remember, guys, this is like a half hour later. I mean, it's an hour later. Here we go.
Defendant is present. The jury sent out
We're an hour later, chat.
another note at 4 p.m. and copies were made and distributed to counsel. Dear Judge Fink, the jury followed your latest instructions and don't believe we can render a unanimous decision on either count. That's signed by the jury foreperson, juror number 1. Then it says we also need clarification on verdict formed. We also need clarification on the verdict forms based on the above. All right. What's the state's position first as to the first issue? Well, as to both, I guess, really, because they're interconnected.
Your Honor, I think we just tell them that if they're at an impasse and can't reach a verdict, then they don't have to do anything with the verdict forms.
I think that answers question number 2. I'd ask that we just reiterate the impasse instruction and ask them to continue deliberating and see if they can make progress.
What about the verdict form? I mean, I'm not sure what.
I mean, that part's that's a good point. Like, if we don't have a verdict, you should tell them don't touch it. That's a fair question. But these two here, I was watching this with Hella on Monday, guys, and these two right here, they kept fucking saying, no, send them back in. More deliberations, more deliberations, deliberate more. I want you shoving deliberations down your throat. More. That's what these two are doing. And I said it at the time. They know something we don't know. They must have seen that jury's reactions throughout the whole trial, and they must have seen this jury was riding on the we don't give a fuck truck. Compared to the state's case, they were on the don't give a fuck truck. They must have known, because they keep pushing for it. They thought they were holding the heater. They're holding a hell of a hand right now, and they're getting ready to play it. I mean, look how does she look confident to you? No, she does not look confident at all right now.
But I'm not sure what that means. I mean, it would seem to me.
I think they're
It would seem to me that if you're at an impasse, you're at an impasse as to everything. And I'm not really sure what the issue would be on the verdict form. That concerns me a little bit. because the possibility of what they're doing on the verdict form might be inconsistent with what they're saying otherwise, but that's some speculation on my part. Yeah.
I think it's because there's not a final checkbox that says we cannot agree on the less final of the lesser includeds. I think that's why they're confused. Because they've probably gone through and decided we can't agree on this, we can't agree on this, and now they're at the third one and there's nowhere to check the box. We can't agree. Do we have to fill it
Oh,
out?
right, because the last lesser included just says guilty or not guilty.
And so does the second count. It doesn't have a we cannot agree. So I think that may be the confusion. Like, do we still have to fill this form out? What do we do with the forms?
Okay.
But, and as to council's first point, I think at this point it would be coercive for us to indicate that they should continue to deliberate, but that would be the state's position, Your Honor, and I would defer to the court on that.
All right, thank you. And defense, and what's your reasoning?
Just that you only gave them that instruction, I think 30 minutes or something before they came back out with what they stated. It's been a long trial. I think they're at the end of a really long day. They looked pretty exhausted when you brought them out here. So I think it would be beneficial to at least give them an opportunity perhaps to break for the day and try again tomorrow. And if they can't, they can't. But you recently gave them that instruction.
So I love their argument of like, well, look, you just told him, Judge, throw him back in there.
My concerns, Judge, is the 30-day trial, the cost, the time, the expense that not only this county, but each of the parties, it's just.
Each of the parties, only one party has a checkbook they have to worry about, and it ain't the state.
It's not an easy one to give up too soon, because then we have to potentially try it again, depending on the state, and that expense will be put out there again.
No, I understand, agree, believe me. Well, what Ms. Larkin is suggesting is that I offer them, once again, the opportunity to avail themselves of another break and come back tomorrow. And I'm willing to do that. I don't. So would you like me to craft a response that basically says that the court can offer you an opportunity once again to, if it would be useful to you, to take another break, come back tomorrow morning and reinitiate jury deliberations?
That works for us, Your Honor.
And then allow them to respond, Judge? Is that the intent, to
Right.
elicit a response from them?
Right.
I don't have any objection to that, Judge, if they think it would be helpful.
I mean, I think you have to offer them something different other than just keep deliberating. That obviously hasn't been productive to keep deliberating right now. But I did notice when they came in, there was obviously, it's difficult to judge, or to draw conclusions from what you see, but there was obviously some frustration there that I hadn't seen before, which is understandable, but a break might help. So, all right, give me a minute.
And then as to the second one, were we going to respond on that? Just tell them if they're at an impasse, they don't have to fill out the verdict forms, or how do we address that?
What's the defense position on that?
Judge, that's fine with us if we could just instruct them that if they can't come to an agreement, they don't have to mark anything on a verdict form.
If you cannot come to an unanimous agreement on any of the charges, then you do not have to fill out the verdict form.
Right.
Okay. Give me a second.
Although, Your Honor, I suppose it's possible that they didn't quite understand the lesser includeds. I don't know if the court wants to just explain to them again. I hate to give up an opportunity for them to resolve the case if they have the ability to do so. I'll just throw that out there for the court.
All right, guys, here we're gonna skip till he starts talking. Let's go. I mean, look at him. Look at him. Look at these two. She looks like she just got a cancer diagnosis. He's like, I look like a fucking idiot. And these two right here and George Kelly are sitting there with smiles, having a joke and a smoke. I mean, one side's got the swagger right now. So here let's hear where they're at, see what they're up to.
All right, so here's what I wrote. The court understands that you have continued to work hard to come to verdicts. The court can offer you the opportunity to once again recess for the evening and to resume deliberations again tomorrow morning if you believe that would be helpful. As to the verdict forms, I am not sure what your issue is without more specificity. If, however, you are unable to reach unanimous verdicts on any count, then you need not fill out the verdict form. Thank you. You will instead report to the court that you simply are not able to reach verdicts. Any objection from the state?
No, Judge.
No objection.
All right, it's 4:18 p.m. I'll give the note to the bailiff with my response. If there's nothing else, we're in recess.
Please rise and people forward.
Thank you. Please be seated. Jury's absent. Yeah, go ahead.
Gotta get George. Here he comes. Here comes that gunslinger now. Look, he's got his cowboy hat and everything.
All right, the records show the presence of the defendant, counsel for both sides.
George, the Arizona rattlesnake Kelly.
The jury sent back another note. This note came in just a couple minutes ago. It was a response to my note, and it says as follows. Thank you, Judge Fink. We do not believe resuming deliberations will change juror opinions. It's signed juror number 1. What's the request of the state?
Your Honor, the state requests that the court declare a mistrial.
And for the record, Judge, we object, and we would ask that they be brought back tomorrow to continue deliberations.
I'm going to, I understand your position.
And this, once again, they're like, fuck it. Make him go back. More. You're not done yet. You're not done yet. Finish it. And look at her. She's like, oh no. She's like, at least I have my cats to go home to. All 10 of them. And he's just like, oh, I'm policeman. Once again, normally if the vet started, I'd be like, oh, mistrial, let's go. But
Position protecting the record, but I think the jury has made it abundantly clear. Beginning yesterday, which was too early, but then they continued to deliberate. They deliberated another hour and a half or 2 hours yesterday afternoon, and not yesterday afternoon, but Friday afternoon, and then deliberated all day today, and they just seemed deadlocked. So I'm going to declare a mistrial. Let's bring in the jurors.
Your Honor, the state would request an opportunity to speak to anyone on the jury who's willing to speak to the state.
As you know, I customarily meet with them first, thank them for their service, and then I'll inform them of your requests.
and that's not uncommon. You get the chance to ask the jurors, hey, can I speak to you, ask questions? It's kind of like 50-50. Sometimes you get a couple of jurors want to talk to you. Most of the time, they're just like this, and they walk out the door. They actually don't flip you off. They're like, nope, I got nothing to say. I'm going home. Thanks, bye. And that's it. You can't go contact him later. You get one shot in the courthouse. Or I've had one guy before. He's like, look, I got to get home. I got to get stuff done at my house. I got to take care of my family. And I gave him my card and said, would you call me? And he called me the next day for about 10 minutes while he was driving to work. And he told me all about the case and what he thought was good, what was bad. So, yeah, this is how you gain intelligence about what happened.
Thank you. And the victims are on the way over, Your Honor.
Ay, los míos. Los victimos. You don't ask in open court.
Set the matter for status in a couple weeks.
So, Casey, you don't ask in open court. No, normally you're just like hanging out there as the jurors come walking out. You're sitting in the courtroom like, hi, can I ask you a question? Or when I've done it, the way it's done sometimes, the judge kicks us out of the courtroom and he takes the jury privately in the courtroom. And I'm just sitting out in the hallway like, hey, can I ask you questions? And sometimes they're like, cool. Sometimes they're like, no, go fuck yourself. And you're like, thank you for your time. Have a great day. And you're like, well, that didn't help. And sometimes nobody wants to talk to you. Not even the prosecutor.
I think we only have 60 days to reset it, Your Honor. So I'd ask that we set it for next Monday. I think we'll have a decision by then.
Meaning they don't know what they're going to do yet. Monday is the deadline.
Okay. Any issue with that from the defense? Setting a status next Monday, so see what the state's position is.
Sure. Would that be afternoon calendar, right?
Yes.
That's fine with me, Judge.
You can appear remotely.
Thank you.
Please rise.
All right, thank you, everyone. Please be seated. The record will show the presence of the jurors, counsel, and the defendant. I've read your note. Juror number 1, I believe you're the designated foreperson. Is that correct? All right, sir. Is it your opinion as the foreperson that if the court were to provide you with additional time and any other resources or any other materials or evidence that I can, that would not be a fruitful endeavor, and you would still, as a juror, be deadlocked and unable to reach a verdict? And is the jury deadlocked and not able to render a unanimous decision on any of the counts? Very well. Any other record that counsel wishes the court to make at this point in time?
No, Your Honor. Thank you.
No, Your Honor.
Very well. Ladies and gentlemen of the jury, I'm going to excuse you.
Now, this is where I don't know Arizona law. I wish I had Robert Gouveia on, because I would say, why aren't you asking for a directed verdict right now? I'd say, Your Honor, can we have a directed verdict? You gave the jury a chance so they couldn't do it. And he could say, yep, fuck the jury. But he didn't. So I don't know why he couldn't. Although I do know you could file post-trial motions. In every state, you're allowed to file motions, set aside verdicts, directed verdicts. Maybe they're going to file a motion for directed verdict. I reached out to both attorneys and sent them an email, asked if they'd be willing to talk, because I'd love to hear from them, because that's a big question I have.
If you'd go back to the jury room, well, you are excused. You are relieved of the admonition of the court. And I'll discuss that with you some more when I come back to the jury room. But it's my practice to always meet with the jurors after the deliberations and after a trial and thank them for their service and answer any questions that you have that I might be able to answer. So if you wouldn't mind, this will just be a moment going back to the jury room. And I know it's 4:35 or so, but I'll be back there very shortly to thank you for your service. You are excused. You're released from the admonition, and you are excused to go back and retire to the jury room.
Please rise, por favor.
All right, please have a seat. The record will show the absence of the jurors based upon the jury's inability to reach a verdict on any account. The court orders that a mistrial, that this case is in mistrial. The court will set a status hearing for next Monday on the court's usual law and motion calendar for 1:30 to allow the state to take a look at the situation and decide whether or not it wishes to ask the court to reset the matter for trial. I also want to remind the parties, notwithstanding that any post-trial motions are due under Rule 20 or any other rule that's applicable within 10 days from today's date. So be aware of those time limits.
Your Honor, the state does have 2 pending motions. It would be very helpful if the court ruled on those because we do need that material to make a decision about what we're going to do next. We've asked for the JAFS recordings of the trial and also copies of the questions by the jury post-closing argument and the court's responses thereto. So we're attempting to make some decisions.
Understood. All right, very well. I'll inform the jury.
This is where I want to know, because at first, I think I know what they were going to be asking until we learned what Kathy tells us after out of court. What does any of that tell you? What does any of that tell you, honey, that helps you make your decision? The true way to make your decision is to poll that jury. Get one, because remember, there's only 8 people in this jury chat. There's 8 people in that room deliberating. Ask one of them what the split was, and ask them, were they hung up on a lesser included? Were they hung up on any of them? All of them? What? Ask them what the totals were. That should tell you what you're going to do and not do.
Of your desire to speak with them, I'm going to go back and thank them for their service. Is there anything else from counsel?
Just that we'd like to speak to them, Your Honor.
Right.
We would too, Judge.
Very well. I'll communicate that to them. I'll give this final note to the clerk, and we are adjourned. Thank you.
Please rise.
Now, you guys are talking about the verdict and all the cops being there. That's actually kind of a big deal. The cops are told, hey, the jury's made a decision. So they were told, I'm sure the judge said, show up. He wants crowd control because guilty, not guilty, people are going to lose their fucking minds in that courtroom. They weren't worried about George Kelly busting out an AK, but they were going to be worried about a lot of different things. So it wasn't just that. It wasn't just that. Now, you guys have a bunch of questions, and I'm going to get to these all in 1 second. What I do want to get to is 2 things. We have 2 statements. One of them is by Kathy, the Texas gunslinger herself. And she gave a very quick interview. Here's the breakdown of the vote.
There was 1 holdout for him. The rest were not guilty. So 7 not guilty, 1 guilty. There was 1 holdout.
State of Arizona, felted. 7-1, not guilty. 7-1, not guilty. If I'm the prosecutor, that's a big pause moment. Because they just realized, like, oh my God, this jury didn't even... Remember, the first day within hours of deliberation beginning, they had it for a couple hours. And then that morning, Friday morning, they're like, Judge, we're stuck. They were stuck right off the bat. I guarantee you that whole time it was 7-1, not guilty. 7-1, not guilty. Yes. Sad! Pathetic! I mean, if I was the state, I wouldn't retry this. I wouldn't. Because you've got to go all the way back up the mountain, and that's hard. But there was another, there was this guy, and he is a person from the Mexican consulate. And here we go.
We will continue to accompany Mr. Cuen-Buitimea's family. This is our role, and we are confident that justice will prevail.
Now, he said, we'll stay with his family. I almost want to ask him, like, Do you know why he was running around across the border without permission? Like, was he working for the cartel, sir? He'd be like, "That's not the funny. We not do the cartel money." Yes, and that's the thing. The state's playing with house money, so it doesn't matter. I don't think they're gonna retry him. That looks really bad. It looks really bad. And this is good. This is big news down there. This is big news down there. This is very big news down in that area. Now, there are a bunch of questions, though. Based on the mistrial, can the judge do a directed verdict? I still think he can. I mean, and I don't see why he couldn't. Benjamin asked a good question, though, here. Why is it... Oh, there we go. Wow, it froze up. Saying, have they ever considered changing the jury foreman when they're in an impasse? That's not usually what happens. They don't change the jury foremans. That's kind of actually a big deal. Kitchen Knife Rescue, yes, he felt very attacked when the defense attorney called him out and he walked. Why is it surprising that someone does something when he feels a slight, he reacts in the same way? Yep. Eric says, so I can't draw dicks on the verdict form? Well, if you do it anonymously, sure. Do you think she knows something and doesn't, the defense knows something and doesn't want the prosecution to know where they screwed up? Maybe tactically during the trial, there are times where, like, if I see the state commit an error, where I know they're going to commit an error, or like I know there's a problem with discovery or the evidence, I might like hide that. But no, normally when they screw up a trial, you bring that up because if you don't object, it's waived. Do you know of any reason not to ask for the directed verdict? I don't know. Like I said, maybe they can ask for it. Maybe they can. Detective Ricky Ritardo doesn't look happy. No, he doesn't. And Selena says, why would they want to talk? Believe it or not, there's a lot of times jurors do want to talk because they know they haven't gotten the whole story. So jurors will ask, like, especially defense attorneys, like, hey, do you think your guy did it? Like, what do you think? Like, how do you feel? And a lot of times they'll want to tell you, like, hey, I think you did a great job. I just didn't, I think you, like, because they'll say, like, I think you did a great job. I think your guy did it anyway. Or they'll ask me questions. They'll say, hey, defense attorney, when you were up there going at the cop about X, Y, and Z, what was that about? And you're like, oh, yeah, well, here's what I was trying to get to. And I know I couldn't bring it in. I was just trying to drag it out a little bit. He's like, that's what I thought. They'll ask that stuff all the time. They have questions themselves. The holdout will talk to her. I don't know who the holdout. We don't know yet. NorCal says the victims were crossing the Rio Grande. Yeah. Kat says, what victims? Remember, victims include family members of the deceased. So that's actually not like a ridiculous thing that they're considered victims. Can they still hold Tex on bond? Oh, yeah. All priors order to the court remain in effect. It's as though the trial never happened. They're in pretrial status now. They're back to pretrial status. So, yeah, George better mind his P's and Q's. Ooh, we got a little bit of wind going outside. And, yep, I got the windows in my car up. Just had to make sure. Robert Lawrence saying a directed verdict should be unconstitutional. Remember, directed verdicts only go one way. Only the defense can ask for a directed verdict. So the state can't. HM saying no retrial. I agree. I fully agree. I hope there is a... Cody Hunt saying, so they have to legally bring the family of an illegal over for his trial. I mean, yeah, they technically have rights under Arizona law. Alpha Fox says, bet the holdout was a 20-year-old Mexican Zoomer. Maybe. Who knows? We don't know. I didn't realize there was a 20-year-old in the jury, but yeah. Does the prosecutor know their evidence is weak, or are they being obtuse? I like I told Hella and Dolly, I think they thought their case was a lot better than it was as they were preparing it and as they started arguing it. I'm sure they woke up that morning on day one and thought they had a banger of a case. I think now in hindsight, they're realizing like, oh my gosh, there are a lot of holes. But I think overall, they're going to say, no, our case is still solid. a lot of that's just confirmation bias from people, and people not willing, anybody in general not willing to recognize that what they've got isn't good. But while also they're prosecutors, they don't ever back down. So there's some of that too. But yes, I think there's a lot of doubling down right now mentally. There's a lot of copium being snorted. Why even retry? If they think he committed a crime, they have every right to retry him. So, let's see here. I had prosecutors ask me why I decided not guilty when I was on a jury, and I told them they didn't have enough evidence. Yeah. And I don't know. Maybe that's the thing. Like, who knows? Who knows what the jury said yet? Hopefully we can find out. Cacophonies, you're saying that it's not going to happen? Dude, like, I brought this up before. I'll bring it up again. You know, this is a very, very blue county. So 2020. Look at the year 2020, okay? And look at that. 60 they BTFO'd the Republicans by 30 points. Okay? That's it. They are not, this is not a problem for them, okay? And here, you know what? We'll bring up the Santa Cruz County Democratic Party. Because they'll show listed, they'll have all their officers listed. All right, here we go. So the Santa Cruz County Democratic Party, right? All right, let's see here. Let me see here. Do we have list of elected officials? That's not, I'm surprised they don't have that. About us, home, mission, executive board, newsroom, blog, resources. Yeah, elections and candidates. Here you go. Oh, like, you know, I thought they'd have like, look, here's all of our people. The Citizens Clean Elections Committee, that doesn't seem like a load of bullshit. That doesn't seem like something out of George Orwell. Oh my gosh. Like, look at this, chat. Look at this. The Citizens Clean Elections Commission. Yeah, I'll pass. LD19 or so. Yeah, guys, I don't know. I can't find it. I can't find it right now, but it's county elections, maybe. You know what? Never mind. I can't find it. But normally they have like a slate of candidates and they say, here's all of our people and we run all these things and look at us. Look how cool we are. So it's a Democrat county, guys. It's a Democrat county. Don't mistake it. There ain't going to be no red wave out there. There ain't going to be no red wave out there. So. It's not about the county. It's a state issue. Well, the county votes locally. Your DA is a county race, so that's the big thing there. Cringe for that all the Democrats are corrupt. Well, I don't know. Here, let's see. Let's do Ballotpedia, Arizona. Let's do Judge Fink. All right. Damn, I hear my neighbor's slamming car doors loudly again. So he was appointed by Jan Brewer back in 2014. Jan Brewer was a Democrat. Yeah, his political affiliation, let's see. Yeah, here we go. Let's bring this up. Yeah, he might be a Democrat, but we'll see. If you guys ever, that Ballotpedia is actually pretty good on giving you basic information about politicians, especially ones in your area. It's not bad to use for overall things. He ran unopposed in the Democratic Party. Not a surprise. There you go. Went to the University of Michigan. Wow, that's a long way away for an Arizona guy. Okay. God, he's been an attorney forever. That he does not look that old. You know that, right? He got his JD in 1984. He does not look that old at all. I mean, so he got his JD. He was like 25 in 1984. I mean, that's almost 40 years ago. He's in his 60s. He's fucking old. Red wave of blood along the border. Okay, well, yeah, that red wave. Yeah, Jan Brewer was not Jim Brewer, Jan Brewer. Yeah, he's at least 60. A bro must lift. Yeah, dang judge dropped the skincare routine. Selena says, cut it out. 60 isn't that old. He doesn't look that old, is the thing. Tilly says he's a CrossFit instructor. He gets those Mexican stem cells. They sneak him over the border for him. So. So, Tilly, this is actually a good question here. How long can they have to do a mistrial? Well, it sounds like they have 60 days under Arizona law. Now, theoretically, though, let's say that didn't exist. The only other thing that would exist is a statute of limitations. So the statute of limitations would be the next time bar. But remember, George Kelly's charged with murder, and guess what? There is no statute of limitations for murder, so he could be tried forever. They could try him 25 times in a row if they wanted to. Although I think in Arizona, if the state doesn't do it within 60 days, this might be dismissed with prejudice. I don't know the story there. I did ask a bunch of questions of the attorneys. Hopefully they get back to me. Yes, he eats children, yes. He drinks foreskin smoothies. Oh, ugh. So, yeah, there we go. So, yeah, that's it. George the Nogales rattlesnake, the Kino Springs rattlesnake. George the Kino Springs rattlesnake Kelly. So, yeah. Anyways, guys, that's it. We'll find out on Monday what happens. I wish I had a better answer for you in the meantime, but we do not. So time will tell. I'd like to think they're not going to try again. I don't know where they think they're going to be. I don't know what they think is going to happen here. I don't know what they think is going to happen. So. I just don't know what's going to happen at this point. So let me see. What do you guys? Let's see where you guys are at. Where's the Judge Torso pick? Jesus Christ. Yeah, so that's it. Yeah, it's just like Ferris Bueller's Day Off. Like, sorry guys, it's over. Why are you still here? Go home. But yeah, thank you guys for being here so much. Were there no other lawyer statements or interviews? Not so far. Not so far. And here's the thing: I don't see Kathy or anybody involved wanting to talk to me until after Monday at the very least. JC says, "What caused the mistrial? Hung jury. They could not make a decision, so they held off." Does he get his guns back? Nope. He's still under indictment for murder. So this is pretend the trial never happened. He's in the same spot. All the evidence that's been seized, like his AK, he doesn't get it back. If he gets acquitted, he could get it back. But until then, it's still evidence for the next trial. So that's it, guys. Yeah. You are very welcome. Too many base jurors. Well, not enough. And we are, we'll find out on Monday what happens. Glad for your commentary. Well, thank you. Thank you very much. We are all caught up right now, guys. A little bit later tonight, 9 o'clock. Actually, hold on here. What time is it? Yeah, 7:15. Hold on one second real quick. All right, guys. So what we're gonna do tonight, we're gonna do as promised, the YouTube members only stream. As I said, I'm gonna quit. We quit merging. We quit docking locals and YouTube members together. We quit putting you guys together. We're doing segregation now. So we did locals last night, and tonight we're gonna do a members only stream. We're gonna be hanging out. And we got some things to talk about, like Alec Baldwin got harassed by a Palestine protester, and it's fucking hilarious. It is so goddamn funny. And these are going to, like I said, just like the Monday streams, this is stuff that doesn't necessarily fit into the Thursday night thing. And we're going to talk about that. I think it should be very funny. And we'll be doing that about 8:30, 8:45-ish time. And I will see you guys then for that. I'm a segregationist. Yes, a little bit. And Ron said, yes, during the jury questions, I told you that one juror sounded guilty no matter what. Yes. And I agree. I think we were all the same for that. I think we were the same. We had that thought that was the one juror trying to chide everybody into understanding things. Was the one guilty vote for all charges? I'm assuming it was guilty for murder. Who knows, though? Maybe it was guilty for one of the lessers. We just don't know. And Sean made trial streams great again. Well, thank you. I tried. JC Adult says, where the white women at? I don't know. I just don't know. Just like the guy in Dirty Harry. I's gots to know. Robert Lawrence gifted 5 memberships. Thank you very, very much. I appreciate your support and your gratitude, and your support and your generosity. Why did I say gratitude? Support and generosity. I know everybody else will appreciate it as well. Yeah, 8:45, 8:30, 8:45 for the next stream. Winter Soldier said all the law chats had that same opinion about the one juror. Well, that's good. Can we at least get a locals chat for the YouTube stream? I won't be watching you guys at all. You guys have the safe house if you want to play around. But if you guys have a chat there, I'm not going to look at it because I'm solely going to be devoted to like here. So, yes. Did they give a breakdown for the charges? What about the ag assault? No, we don't know how it broke down. It's just we know it was 7-1. So I'm assuming that one juror wanted to convict for both, and all 7, the rest of the 7 said nope on everything. From what we can tell. And I need a locals chat for people to post lewd photos. I will nuke my locals before I let that happen. I'm not joking. So, we're all set, guys. Actually, hold on. Why did I not? What am I missing here? Oh, I didn't have this going. I feel like a dumbass. You know what? We'll just call it 8:45 and call it good now. We'll call it good now at 8:45. So, I know I just sent. You heard that, chat. Oh my God, it's big. You heard her, chat. Very well, until next time, chat. I will see you guys. Jim says only 8 for a murder trial. I thought it was 12 no matter where. Nope. Anywhere from 6 to 12 is the standard. Florida, you only get 6. Arizona, you get 8. A lot of states, like in Ohio, a felony trial, you are constitutionally protected. Under the Ohio Constitution, you get 12, but not every state's that way. Good question, though, Jim. And we will... Chief Gunman is a new member. Thank you, Chief Gunman. I will see you guys tonight at 8:45. Bella, we're doing our members-only stream and hanging out. So it should be a lot of fun. So take care, everybody, and remember, even though George Kelly did it, he is still not guilty. Still not guilty. Take care, everybody. Good night.